Good morning to all of you. This video is for the Civil Procedure Code students. Yesterday, somehow we completed the syllabus because time is running and if it will stop for anybody, I am going to tell you the Limitation Act. Don't worry. Right. So, as far as CPC is concerned, yesterday we had discussed important points. Out of them, Section 148A of the CPC is important. It deals with the caveat. What is caveat? So we call it as caveat also. So please remember, as per Section 148A of the CPC, which is a right to lodge a caveat. Right? What is a caveat? Basically, let us know. Caveat is the Latin term which means let a person beware. Let a person beware. That means let the other person know. This has originated in the 16th century. Right? So please remember, it may be understood that particularly as regards 148A, no injunction should be given without hearing the other side. Caveat is a request or intimation or an alert to the court by filing a petition that the court may not hesitate, may not take any urgent action like giving ex parte ad interim injunction like that without hearing the other side. So definitely you can take the course of caveat, right? Where an application is expected to be made, where the defendant or plaintiff is suspecting that an application may be made for getting injunction or other things, then you can lodge a caveat. Please remember, according to 148A clause 1, if the caveat petition is lodged, please remember, the court will serve a notice of the copy of the plaint or order or the interlocutory application, hear the other side, and then only they will take action. So this is the advantage. Please remember, whenever you get a doubt that somebody is likely to get an injunction order, then if you file a caveat, the court will give a notice to you, it will hear you. Of course, it is the prerogative of the court to give you injunction or not. But you can stop it for some time. This is the advantage of filing a caveat. Before forgetting, let me tell you, the life of the caveat is 3 months. You can extend it for any time. But you cannot take a permanent caveat just like a permanent or perpetual injunction. The procedure, the advantage of the caveat is the other party cannot get directly the relief he wanted. Already I told you, for getting an interim injunction order under Order 39 or Section 94 of the CPC, normally no case is necessary. Just a petition, application itself is sufficient. So in such cases, lot of damage will be done to you if the other side gets an order like an injunction order. So if you suspect the same, yes, you can alert the court. You can request the court, right? So please remember, who can file the caveat? You can lodge. Normally they use the word as lodge. Who can lodge the caveat? Please remember, any person claiming a right of appeal, right to appear before the court. And please remember, there are certain duties cast on the caveator also. Please remember. So this clause is directive in nature. So please remember, this caveat application, a copy of which should be served to the other party. I told you in the class, the procedure we adopt, because if the notice is served on the other party, there will be ramifications in the other way. But anyway, as per the procedure, yes, it is your duty to give a copy. For that purpose, I told you, notice should be given in each and every instance, even for counter affidavit, even for counter claim, for whatever it is, you have to give a notice to the other party. Please remember, right? So, what is the object of this Section 148A? Please remember, it is to protect the interest of the general public. It is a public policy. Unnecessarily, we should not face the unnecessary orders of the court. So the case law is, please remember, Reserve Bank of India Employees Association versus the Reserve Bank of India and others. I think I will give you the notes also. Already yesterday I told you. So there is a caveat that these people, the association people, they have filed. So please remember that the Reserve Bank of India may give some orders against to them. Actually, it was a revision petition under 115 of the CPC. So please remember, this is the application by RBI is regarding the prohibition, grant of injunction order. Okay, yes, it's grant of injunction order against any meeting, any demonstrator, or resorting to any form of direct action by the so-called Reserve Bank of Employees Association. Reserve Bank wanted to get an injunction order, but Reserve Bank Employees Association, they filed a caveat, as a result of which they were successful, because yes, you know, in democracy or according to Labour Act, if they give a notice, they can go on strike, they can do dharna, they can stage it up, so many things they can do. So with the advantage of the caveat petition, this RBI case, they were able to get the favorable evidence to them. So please remember, another case, important cases, B. Santosh versus Jagatram and another. Right? This is also another case. So please remember, another case is C.G. Siddhalingappa versus G.C. Veeranna. Right? So in this case, the important point is whether the judge could have passed an ex parte order, even in the case where a caveat was filed. Normally, no. Right? So this is the importance of the caveat. It protects the person who files the caveat person. So very classic example of Audi, alterm, partem. Here the other side. Of course, it is the prerogative of the court to take a decision. So don't be under the wrong impression that since we filed the caveat, no injunction order will be given. After hearing you, the court may give injunction orders. Is it not? So for the present, this is the notes regarding the caveat, which is an important point. Already Mr. Muppara Pravi, I think he might have circulated the notes given on me also. Actually, I have also taken it from C.K. Takwani book. It's an very important book. Please read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.